Welcome to the PinLeader podcast, where strategic leaders get straight to the topics, strengthening our awareness and sharpening our minds. The PinLeader podcast is produced by Roar, a production division of Mays & Associates Ltd. Find out more at www.maysassociatesltd.com. Now here is your award-winning host, Dr. Shan DeGore.
Welcome back to the PinLeader podcast. And I have today with me a wonderful guest that has so much experience, 50 years experience in an area that some of us, when we talk about leadership, sometimes we forget or we don't realize that we need a partner who has this type and this level of experience. But I'd like to welcome to the show Mr. Chuck Schaub, who is an experienced patent lawyer in a wide variety of technical fields. He has that more than 50 years experience. He has experience with multinational Fortune 500 companies as well as many individual inventors. His experience ranges in medical devices to automotive components. He's well-versed in licensing agreements, trademark, and copyright, and he's been employed and then, is helping lead a firm right now. He has been the past president of a number of foundations and boards. He gives back to the community. And what's also exciting about what he was sharing is he also sees himself as a mediocre participant in squash, tennis, and cycling. And I don't believe the word mediocre, that you do anything in mediocre, but I appreciate that you shared that because hobbies are very needed in leadership too. So I want to say thank you so much and welcome Chuck Schaub. Hello, Chuck.
Hello, Shanda. How are you today?
I'm doing very well. Thank you for coming on the show.
Well, I'm happy to be here. I hope I can provide some insights and maybe a few comments that might be of interest to your listeners.
I would really appreciate that. I think that there's something said about trademarking and copyright and as leaders, especially if you own a business or you're involved in a business and you come up with new ideas, you may get very busy in the middle of being a leader with that idea, but there's parts that really need to be protected. And I think that's really what the heart of what we're going to be talking about today, and protecting your genius. So can you share just a roadmap on what you see and what you suggest if someone does come up with an original idea?
It's always interesting when someone does that and they have something that looks like it has commercial potential. Certainly the best thing you can do is to start documenting that this is your idea and trying to fill out how it's going to work. Would suggest that you want to talk with a lawyer that is experienced in that field. Go over the concept. You may do some patent searching. You may do some other investigating, and sit down and analyze the commercial potential. Almost everything in my field of the law is the actions that are taken are based upon the value of the technology. I always joke with clients and say, if you've got an invention that looks like it's 95% patentable, but nobody wants to buy it, who cares? At the same time, if you've got something that looks like it's 5% patentable and you can't make them fast enough, we're going to want to try and protect that. It has value. And so that's kind of my approach to all areas of intellectual property. You're trying to protect things that have value. And I always like putting the client in a position where they're making affirmative decisions on how to proceed. A lot of times you'll get somebody that comes in and, we've been making this for 3 years and selling it for 3 years. Okay, it's too late. You've missed the opportunity to protect it. So I'm trying to counsel clients to come in, talk with us, look at the ideas. Maybe we do some research on them, get some background information, and then you can make an informed decision as the business owner or the inventor how you want to proceed. And I like that approach a whole lot better than saying, this is out of your hands. You no longer have an option for doing this. And most clients are pretty receptive to that. They say, okay, let's do that. But I also have to admit, in today's world, people are so busy that it's hard to get them to concentrate on things that aren't maybe the specific thing they have to get done that day to keep their business operating. So it's always a little bit of a battle to get them to look into the crystal ball and say, all right, this is important. We need to spend the time and effort to look at this and make informed decisions.
Well, and there's a couple of points there. I think it's very important because you were talking about the length of time that needs to go by. That, first of all, you're trying to figure out, is this really viable or not? And then, of course, you don't want to miss the window. And so is there a kind of a range of a sweet spot of like when people do come up with it and then they're sharing it with others? I mean, what's your thoughts?
There's definitely a sweet spot. You have, under the U.S. patent laws, 1 year from when you first offer something for sale, use it commercially, or publish to file a patent application. You go beyond that, and it's in the public domain. You may come up with an improvement that will make it a little bit better, and you could possibly patent the improvement, but you would have lost the basic concept. The other factor that has changed is the U.S. patent system is now a first to the patent office. It used to be the first to invent. So if you could establish that you invented it first, even if somebody else filed a patent application before you, you could show that it was your technology and you had rights to it. Now the first person to get to the patent office has the rights, and the only way you can really offset that is if you can show that somehow they derived it from you, that they had information from you and that it wasn't really their concept. They basically stole it from you. And so that changes the dynamics considerably. So if you're going to go out and talk to people about the concept, which is frequently exactly what you want to do, you want to get people excited about it and
if it's worth it, right?
Yeah, to see if it's worth it, if there's value there. So that's something that people frequently do. But in today's world, we would counsel people to file something before you go out and start disclosing it to others, because you never know when somebody else files that patent application. And, you could say arguably you have the ability to offset that, but it's a real uphill battle.
Can you share too, I think there's confusion on, well, what exactly is this? So for example, if it's, do I do a trademark? Do I do a copyright? Do I license? What can you share? What are the differences between those?
Okay. Patents cover concepts, technology, a machine, a method for doing something, and it gives you protection on that concept. A trademark is something that you use to identify goods or services that you sell, and it's specific to those goods and services for the most part. And copyright is something that protects something that you've put in a tangible medium, which is a terrible term that they use in the Copyright Office, but it means it's fixed in some way. It's a book, it's a song, it's something that people can look at, a computer program, and you can say, I created that, and I'm entitled to protection for that. So there are three separate types of protection. They all have their values. Obviously, if you're an author, a musician, copyright is extremely important. If you run a business, Nike sells a whole lot of stuff under the name Nike. People buy it because whether they like Nike or not, it's well known, and they've developed that market. Things like Coca-Cola, same thing. People really buy into that marketing. And on the patent side, there are very few businesses, especially in the Midwest, that if you go back into their history, there isn't some technology that they developed and more than likely patented at one time that helped form the basis of their company. And so there's a lot of technical components to a lot of companies that it kind of got them started and made the whole thing work. And so there's separate types of protection, and frequently somebody may come up with a patentable concept and start a business. Then they end up doing a trademark on the name that they use for the business and maybe the products that they sell. And And they get to the point where they're doing advertising, and they may want to have good copyright protection on their advertising that they produce, so other people don't steal it from them. And so they all fit together, but they're separate components of the intellectual property. And I think the internet and social media and a lot of other things have generated people looking at establishing businesses and trying to protect things that they have created. So I'm not surprised at that. I think there's a bit of a entrepreneurship boom in the country right now. A lot of people looking to say, gee, I want to do something a little different. I'm going to take my ideas and try and do something with them, maybe create a business. And if I create that business, I need to protect the ways I identify my products that I'm going to sell. And so I think that's probably just a big part of it. And people through the COVID time period had a lot of time to sit around by themselves and come up with ideas and say, gee, I might as well pursue these. What else am I doing? So I can't go out. I can't go and do all these things that I used to do. So now I'm going to spend some time following up on some of these concepts that I had.
Well, that's another thing too, is I wonder when you said not first to invent, but first who gets to the patent office. Can you talk a little bit about, because there's cost associated with this, and I know that makes people hesitant, and there's ranging of, and then we'll get into a question about fraud, because I know there's a lot of fraud going on within that too. But can you talk about costs and what someone could expect to protect their genius?
Sure. On the patent side, it ranges a lawfully lot based on the technology. If things are very complicated, it's obviously more expensive to do that. But to file a patent application and go through the process to get to a patent, you're probably looking at spending somewhere between, I don't know, $5,000 and $20,000, and some of the costs are predictable, and some of them are not. Once you file a patent application, it is examined by a patent examiner, and they make some determinations on whether or not it's patentable. Then you have the ability to go in and contest those positions, and sometimes that is a relatively straightforward process, and sometimes it is extremely complicated, and it can take quite a while. And so the cost can be very variable, and depends on how you go through the process. And as part of that, I think you're always looking at, we've spent this much money so far, what's the technology doing for us, and does it continue to make sense to keep spending money? And hopefully most of the time the answer to that is yes, it does. It has value to the individual or the company that's involved. So those are kind of rough ranges, and I know it's not very helpful to probably a listener to say, gee, but what I would suggest is that you always want to sit down with whoever it is you're talking to that might be helping you protect it, and always ask for estimates. Make sure that that's a part of the discussion. I always tell clients, all right, when we go through a little bit of this, I'm going to tell you what I think it's going to cost, because that's extremely important to you. That helps you make a decision, again, an informed decision on whether or not you move forward. And so I think that's a critical juncture that you always have to have. And occasionally there are some things, you look at the client and say, all right, I'm not really sure, you're in a dispute. I'm not sure what this is going to cost you, but how about if we spend this much money and see where we're at, and then we can reassess, and if it makes sense that, yeah, it's still worthwhile pursuing, we can keep pursuing that. But most of the time with a patent, a trademark, or a copyright, you can get a pretty good sense of what the initial costs are going to be, and what's fairly reasonable. And then I think it helps the business make a decision. Yes, that makes sense to invest the money. And frequently, businesses have spent a whole lot of money developing this new technology. They maybe have committed a whole lot of money into putting it into the marketplace.
Very expensive.
Yeah. Building the machinery, whatever's necessary, and hopefully most of the time the patent cost and the trademark cost are a relatively small portion of that expense. Again, not something that you ignore, but if you've spent millions of dollars developing this and you're going to spend millions putting the equipment together to make it and more millions to go out and promote it in the marketplace, spending $10,000 or $20,000 on a patent, again, you don't ignore that, but it's probably not the biggest consideration they're thinking about if it looks like it's something that's really going to make money for the company.
That's, I want to go further with that, thinking about those companies that are actually pursuing it. They want to know, they want to go forward and say they get to the stage where they do it. What's interesting about it, and I've experienced this too, is that all of a sudden you may have filed, but then you start getting letters in the mail from agencies you've not heard of that are asking you to also file, that you haven't filed and that you should file, and to pay them an additional fee to go ahead and file. Luckily, legal support, that sounds fraudulent, but can you, there seems to be a whole crop of companies that go behind when a true filing has happened and then basically try to plant a seed of doubt that it was actually done.
Yes, there's a lot of that, and I have to be honest with you in that those companies have been very creative. They've put together things that look very official. They send it out in a way that it looks very official, and basically they're just fishing to get business from people, and frequently it is there's no reason to do it. We see it all the time when trademarks need to be renewed. And sometimes even maintenance fees on patents, that these companies will send things out to the trademark owner or the patent owner and say, gee, this fee is coming up, and it looks like an official communication from the trademark office or the patent office. And actually it is the U.S. Patent and Trademark Office that they're together, but and it looks official. And, we have clients all the time that will call us and say, I thought you guys were handling this, and it's like, yes, we are. And it used to be we would send notices out to clients that these fees would be coming up and give them, a reasonable time period to make a decision, maybe 6 months. And the companies that are trying to solicit this business kept making their offers earlier and earlier. So we've had to adjust and give our clients earlier notice because these companies are sending out notices to them, and luckily most of the clients are sophisticated enough that they'll call us and say, or send it to us and say, what's this? And and we'll say, you can ignore that. That's and it's surprising, a lot of them look like they're coming from the patent office or the trademark office. I mean, they have put their material together well enough that it really does look official.
Well, that's a good word to anyone who's listening to, especially if you're thinking about this. It can be affordable, but you have to be prepared to pay costs to make sure that you can protect your genius. But you also have to make sure that others are not trying to go behind and try to get you to double pay, and then nothing comes of it. And that's a concern. It's like, in so many situations, there's always fraud that follows in different ways, but that's an instance. I want to talk about those million of leaders that are out there trying to get this patent according to the filings. How many in your estimate, and you've had so many years experience, you actually wind up in court, and you've been in court with clients. Can you give an example? I think about these million individuals who have filed their patent. They may have to wind up in litigation. What have you seen? Can you give us an example of like a best and worst case scenario?
Certainly can give you a couple of examples. And one of the limitations of the system is that your rights are there, but to assert those rights, you're talking about going to court, and going to court is an expensive proposition. Patent litigation in particular is extremely expensive. Years ago, we were involved in a case where a fellow that had a lot of different patent rights had sued a client, and And it went to trial. We tried to settle it, and the patent owner ended up with a very substantial verdict in their favor. We tried to settle the case, and our client didn't want to, but the patent owner ended up with a very substantial verdict. Another case, we had a client that had been sued, and we found that we litigated and the patent was held to be invalid. So our client won, and the patent owner had licensed this technology to a bunch of other companies. And once the patent was held invalid, it's invalid for everybody, not just with our client.
No.
And again, that was a case that we tried to settle, and the patent owner was not willing to do so, and was a little bit shocked when he realized his patent was now invalid, and that invalid meant it's invalid, period, not just with regard to the litigants, but it's invalid. And so it can go both ways. And I've also seen cases where the cost of litigation was so extensive that people were basically not quite forced, but close to forced to settling it in some way that it just didn't make sense. The cost was going to exceed what the reasonable value was for many years, and eventually you come up with some way to resolve that.
Mm-hmm. So in other words, if you can settle and you can figure that out to save the court costs, do it, is what you're advising. But it's not always the case. And then if you go to trial, it could wind up in a direction that it wouldn't necessarily be in your favor. So you have to be mindful, because having a jury in front of you, and what's the highest court you've had to go into?
I've only been in district court, federal district court, and we've always told clients that when it comes down to litigation, do you really want a judge or a jury to make a decision that's important to you? They don't know anything about you. They don't know anything about your company. They're going to hear some limited facts in the trial. With regard to patents in particular, a lot of it may be very confusing to them. And when it's all done, you're going to step back and say, gee, I wonder what either that judge or that jury is going to do. We think it's a lot better to be in control of the process and hopefully come up with some resolution that makes sense for both sides. That usually that's a better result. In most of the cases, I can't give you a current statistic, but most litigation, not only in the patent, trademark, copyright area, but almost all civil litigation, somewhere in excess of 90% of it gets settled. I think the combatants decide that that's the smartest thing to do.
So that's good advisement too. Do you have any, when we talk about leaderships and pin leadership, we talk about, sharpening, being experienced, getting the education to help you be stronger in whatever field you're in, and staying the course, whatever that course and strategic plan you've got, and having strength to weather the storms. Part of this that I'm hearing right now makes me think going through, you need to weather, push forward. If you really believe in your idea, you have to push through and have all of those attributes to be able to be successful as a leader in whatever you're working on or trying to bring to market. Out of those, which one do you think is probably the first thing that you would advise if you were prioritizing?
If I was prioritizing, I guess I would say being able to and willing to do the work. We've all been involved in organizations or committees, and the rule is always that there's 10 or 20% of the people that are willing to actually do something. And I think that's a big part of it. Even in business, you have to be one of the people that's willing to pick up the laboring oar and do the work. And I think that's a big part of the leadership. And I also look at being fairly flexible. We'll see people that develop a new concept, and they're the inventor and they're pushing it, and they may be extremely good at being an inventor, But then it moves to the next level, and now they've got to make the product, and maybe they have to bring somebody else in to make it, and they kind of get it up and running a bit, and then they may need somebody that can bring resources. Now we need to take this to another level. We need to build a factory. We need to get marketing, and to be able to step back and say, gee, I'm the guy that got it to this point, but can I take it to the next level? The person to take it to the next level. And if I can't, am I flexible enough that I can bring in other people to help me do that? And I've seen it work both ways. I've seen inventors that thought they could do everything, and some of them have survived. Some of them have augured into the ground. But most of the time, the people that are willing to look at themselves and say, I gave my component and that was good. I'd like to stay in somewhat of control, but I need other people to help me and bring those people in. I think that flexibility is a good part of leadership also. And as part of that, I've also seen clients that when they move from the initial step to the next step to bring somebody in, they're willing to give up a significant portion of what they've created. Well, I'll give this person half of the rights to this, and I'll look at them and say, that's nice. But when you go to the next level and that person wants a percentage, whose percentage it's going to come out of? It's going to be yours. And you've already given away half of your rights, so you've got half to work with. And maybe the person has the other half is willing to share, but don't count on that if you don't have. If it's a family member, maybe it's fine, but just be very careful how much control you give up when you're developing this. You need to have that flexibility. So I think you need all those components you've talked about, but I think keeping some flexibility and some realization what your skills are, and if you need to bring in other people to help supplement your skills, that's a good sign of leadership also.
Excellent. Yeah, identifying where you need help and being able to ask for it, I think really critical. That's a great point. So first of all, I want to say thank you so much, Chuck, for coming on the show, talking and sharing your wisdom about this area. I'm really hoping that individuals who have been thinking about trademarking or copyright, I hope this clears the air on the different levels and then what to go about to do. I also would love to say thank you to everyone who's listening. And again, I hope you got enough from Chuck as well. So Chuck, thank you so much.
Thank you, and thank you to your listeners.
Excellent. So with that said, I want to make sure to keep in mind that the show has always been about getting straight to the point. And I think today is another great example of getting straight to the point with your business and protecting it. Strengthening your awareness and sharpening your mind. So until next time.
The PinLeader podcast is hosted by Dr. Shan DeGore and brought to you by Mays & Associates LTD, creating customized solutions for growth in the areas of leadership development, strategic planning, and culture building. Find out more at www.maysassociatesltd.com. Don't forget to subscribe to the PinLeader podcast and share with others.